on this matter.
Alliance to Protect the Nantucket Sound versus the Energy Facility Siting Board.
Mr. Heffernan, good morning.
Madam Chief Justice, may it please the Court, I'm Lawrence Heffernan, and I represent the appellant in this matter, the Alliance to Protect the Nantucket Sound. The Alliance brings this appeal before this Court because the Energy Facilities Siting Board failed to notify it and the other parties of the standard for determining need of the transmission lines in question, thereby depriving the Alliance of a fair and reasonable opportunity to prepare and present evidence and argument on the relevant issues. The Board also failed to apply that standard and thereby failed to discharge its statutory responsibility to determine need. The Energy Facilities Siting Board issued its final decision in May 11th of 2005. After that, the Alliance filed a petition for judicial review.
Well, what would you have proposed the board do? I mean, in the end, you would want that the wind farm would not be built. Is that right?
Well, Your Honor, ultimately we do oppose the wind farm, but what we want is a fair and reasonable opportunity to present evidence and argument. We submit what the Energy Facilities Siting Board should have done was advise the parties of the standard for determining need for the transmission lines in question at the beginning of the proceedings as opposed to the end when it was concluded.
But you had an opportunity then to present briefing after that.
Your Honor, we had an opportunity to present briefing, both sides did, before the tentative decision was announced. What happened procedurally was there was evidentiary hearings from July through October of 2003. However, before that, there were procedural motions brought by both parties. There was a motion by the Alliance to suspend the proceedings, and there was also a motion by Cape Wind to strike certain pre-filed direct testimony that the Alliance was submitting relative to economic reliability and efficiency.
Mr. Heffernan, forgive me for interrupting you. I know what the old standard is, and I recognize the new standard. Let us assume that you are correct, that you should have been given an opportunity. In light of the current status of the project, what evidence could the Alliance have brought concerning the likelihood of this project going forward, which, as I understand it, is subject to endless kinds of permitting? I mean, there may be something wrong with the standard that the board has now promulgated, but what does I don't think you have that burden, but I'm trying to think of what you could possibly have done on likelihood.
Yes, Your Honor, and the prong of the new test that the board announced, the power that the transmission lines will carry likely to be available was a new standard, and the parties were not aware of it ahead of time. What we could have presented, Your Honor, this focused on the process, if you will, and the likelihood of the generating facility coming online.
Well, I finish what you were going to say.
Your Honor, we could have presented evidence relative to the permitting process, which was stalled and unlikely, whether there was progress going to be made, whether it was likely to become available as a result of the permitting process. Indeed, in its final decision, the Siting Board stated that the progress of the permitting was an indicator that it should take into account. In addition, Your Honor, we could have presented evidence relative to the financing and the likelihood or unlikelihood.
Didn't the board take account of all that, though, Mr. Heffernan, because they said that effectively they said that it wouldn't be built if it weren't permitted and if it weren't financed, so that didn't their decision actually take into account all the things that you're saying?
Well, no, Your Honor, there wasn't any evidence presented, or there wasn't sufficient evidence presented relative to the likely availability. And in fact, Your Honor, the
Likely availability of what?
Of the generating facility, the wind turbines coming online. In fact, Your Honor, the Siting Board stated in its final decision that they could not yet find availability.
Mr. Heffernan, could I ask you this? In essence, it seems to me that it's a very bizarre standard. I mean, because I don't know how you could ever meet the standard unless, I just don't know how, when you've got this whole permitting process. It seems to me essentially what the board has done here is proceed as if it could issue a contingent permit. That is to say, we're going to do the permit taking into account its new standard, the first prong of the new standard. but it's a contingent permit. Because obviously you're not going to, this happens to be an unusual project, but let's assume that you're on an all-land project. Is there some impediment to issuing what is in effect a contingent permit? I mean, of course, if the project doesn't go forward, I take it that there's no permit, or there's no claim here that there's a permit.
Your Honor, the impediment is the statutory charge to the siting board that it has to determine the need for the transmission lines.
But that it's done.
Excuse me, Your Honor?
Hasn't it done that?
I mean, it has taken a simple position. If the wind turbines are built and allowed to go forward, these transmission lines are needed. If the wind farm is not built, they are not needed. That seems so elementary and so common sense that I have a hard time seeing what's wrong with it. Why should the board have this gargantuan hearing trying to predict the outcome of a very complex process rather than just make the permit contingent on the actual outcome? There, everybody can be heard on the actual federal proceedings involving this, and
the error, Your Honor, in that finding or that proceeding is that it ignores the role of the siting board as a gatekeeper, the key role it plays in determining the need for the transmission lines. In effect, what the siting board did, putting aside the fact that it announced the standard and then it said it could not meet the standard, what in effect the siting board did was abdicate the responsibility for determining the need for the transmission lines to other agencies.
But isn't that precisely the role of the Energy Facilities Siting Board, is to identify the major issues that will need to be resolved in further adjudicatory hearings or evidentiary type hearings, and to make sure that certain concepts are considered and resolved at a later date? Isn't that the purpose of the Facility Siting Board?
Well, Your Honor, it is. There are a whole roster of agencies that have to pass on this type of project, but the siting board plays the gatekeeper role, the primary role.
Explain the gatekeeper role to me again. I mean, in this context, I mean, this is all about the turbines, which is not before the board. It's all about the turbines. If as Justice Sussman suggested, if they are built, these lines will absolutely be necessary. I don't even think it's an open question. If they're not built, they won't. It's all about the turbines, an issue not even before the board.
Well, Your Honor, it is before the board in that the board has to determine the need for the transmission lines, and that invariably is interconnected with the energy facility, the generating facility. And the board has to make the determination of need. What the board did here was say, we're abdicating that responsibility, we're delegating it to other agencies.
The need for the generator?
Well, Your Honor, I mean, you can't.
The generator is not before the board.
No, it's not, Your Honor, but you can't determine whether the need for the transmission lines that will carry that power will be there unless you take a look at the generating facility. And the way the siting board dealt with that, Your Honor, was to say, the standard you have to prove, which we didn't have a chance to prove or disprove, is whether the energy facility, the generating facility, is likely to become available. If it's not likely to become available, then you don't need the transmission lines.
So we're going to have a multi-year permitting process before the Energy Facilities Siting Board on a matter not actually before the Energy Facilities Siting Board to determine the obvious, that if this huge new generating capacity is built, transmission lines will be needed. I mean, isn't that just putting the cart in front of the horse in these circumstances?
Your Honor, there is a cart and a horse issue here, and I submit that you don't, before the generating facility comes online, you don't decide or you don't determine that the transmission line should be allowed and should be constructed.
Well, what do? You wait until the generator is built, and then you have several years of hearings to decide whether the transmission lines are necessary, so you have the generator sitting there unused for several years?
Well,
is that what you're suggesting?
Well, what the siting board suggested is that it determined whether the generating facility, the power generator, was likely to become available. That's how they dealt with that dilemma, Your Honor, and we don't necessarily dispute that. What we dispute is that we never had a chance.
No, I understand your argument and the question. I mean, and I will ask the board. I mean, this is the most peculiar standard because I don't know how anybody. I don't know how one could present evidence and then the board reach a conclusion on the likelihood of something coming online and to a challenge that the finding was arbitrary and capricious. I don't see how you could ever evaluate that finding. But leaving that aside, could you just help me on one thing? Could you tell me what specifically was wrong with the Turner's Falls? I mean, I know it was inconsistent with the legislation, but what was the likelihood to come online piece? Why was the board? I can ask the board this, but why was that included in its new standard? What was wrong with the Turner's Falls standard that the new standard sought to correct?
Well, as I understand it, Your Honor, Turner Falls was adapted or was abandoned because of the change in the statute and because they couldn't, the siting board could no longer conduct an analysis, necessarily a direct analysis of the generating facility itself, a non-jurisdictional generating facility. So the way that the siting board dealt with that was to establish a two-pronged standard. One, that the transmission line, the existing transmission system is inadequate, and secondly, that the applicant...
Let me put it this way. If we had just, and I'm going to ask the board the same thing, if one had just the first prong, that the existing facilities are inadequate, which seems to me is what lies at the heart of most siting decisions, not just transmission lines. You don't have enough garbage disposal places. You don't have enough affordable housing. That's essentially what those siting decisions are. Why would one need a likelihood of the facility being built?
Your Honor.
In other words, put it this way: if I'm now the turbine developer, and I don't know whether or not the siting board is going to, because there is a horse and cart, chicken and egg problem, and I need to know that the state agency that has jurisdiction over siting of certain aspects is not going to come at the ninth hour and say, we've got perfectly adequate supply of energy here. So I don't care if your turbines need transmission lines. We don't need additional energy. It seemed to me that in that sense, the board operates as a gatekeeper.
Yes, Your Honor, and I'm not quite following the whole thread of the question, but I think the board doesn't necessarily determine ultimately the need for the generating facility, but you determine the need for the transmission lines. You're not going to need those lines.
I understand that.
The generating facilities
Correct,
doesn't come up.
it seems to me that in some ways, what the board has done is impose a higher standard on the applicant, telling the applicant, we're not going to be satisfied with your just proving a likelihood that you will get these permits. We won't let you have an approval from us until you actually have those permits. They've in fact set a higher standard, and I have a hard time seeing how your client can complain about that.
But, Your Honor, but ultimately the board has to determine the need for the transmission lines.
And they've said that the only way that they're going to accept and make a finding of actual need is not based on likelihood, but based on certainty and actuality. When Cape Wind shows up with all the assortment of permits that it has to have for this project, until then, they don't have a green light from EFSB. What more can you ask for?
Well, Your Honor, I don't think that the siting board should be allowed to delegate its responsibility for determining the need for transmission lines to other agencies.
It's not. It's making a contingent determination. Somebody else over there, in this case, federal authorities, because of where the turbines are, somebody else over there is going to determine whether or not these turbines meet whatever requirements are required to be met. Your client is not claiming that if it's built, transmission lines aren't needed. In other words, there's some other way for for the energy to reach consumers, correct?
Well, Your Honor, it's as to, I suppose, yeah, that is the only way for these undersea cables, according to the board, were the one way in which to transmit the energy.
Okay. I did ask you a long and confusing question. Is there anything that would require the board to have the second prong of its new standard? In other words, if this new standard consisted only of the first prong, would that be consistent with what the legislature has delegated to the board to do?
Your Honor, I think the second prong is necessary, if you will, because the board has to determine the need for the transmission lines, and the way it dealt with that issue was to adopt the second prong, the likely to be available test. And I would point out to the court that this court stated in the Point of Pines case that in which the siting board, in effect, delegated the responsibility to another agency, just as is happening here. They said, the court said, you cannot delegate that ultimate authority to another agency. Here, in effect, what they're doing, they're delegating it to a federal agency. And we respectfully request the court to vacate the finding of the siting board and remand this case to the siting board with directions to deny the petition or, in the alternative, to conduct further proceedings to give us an opportunity to present evidence and argument with respect to the recently articulated test.
Thank you, Mr. Heffernan. Mr. D'Angelo?
Thank you. This was the first case since the 1997 Act in which the board was asked to determine need for transmission lines proposed to serve non-jurisdictional generator that had not yet been constructed. To address the Chief Justice's question about what was inappropriate about the pre-1997 standard, is that the pre-1997 standard would have looked at need for the transmission lines and need for the non-jurisdictional
I understand that. So if that's the case,
Excuse me.
Why did you need the second prong?
The likely to be available prong was the board's way of ensuring that the transmission lines aren't built and never used. So they're going to focus only on the transmission lines. They're going to determine if the existing transmission system is inadequate, which they found here it was, a fact finding that's not at issue in this case. And then they also looked at whether or not the generator will be built.
Forgive me, Mr. D'Angelo. Is it permissible for the board to issue a contingent license?
Yes, Your Honor.
Then what difference does it make? Let's assume that the board finds that it's not likely. Okay? It's not likely. But then it turns out that the turbines, in fact, get built, that there's a lot of opposition, but, for whatever reasons, there's a change of administration. Who knows? And then all of a sudden you've got these turbines. What's it going to do to that? I mean, the standard seems to me to be so unhelpful if you're trying to review whether the board has acted in an appropriate manner.
Well, the board did say in its decision, as it was enunciating this new standard, that this would be a case-by-case determination. There may be cases where the non-jurisdictional generator is significantly further down the permitting line.
But you can't. That goes to, it seems to me, Alliance's fundamental problem here, which is, first of all, you change the standard. You switched horses in the middle of the stream. But second, they haven't been able to even present evidence on whether it's likely or not. So let's assume they come in to show it's not likely. It's just not likely. And the board says, no, I disagree with you. We think it's likely. The board makes a finding of likelihood. The Alliance comes up here and says the board acted, there's not substantial evidence in the record to support the board's finding. And so we agree with the Alliance, theoretically. What does that do to the permit?
I think the difference is the board was not saying in its decision, was not saying it would predict what other permitting agencies and federal permitting agencies would do. It would look at the status of the permitting process, which in this case, again, was a factual matter, not disputed, that there are a number of permits yet to be obtained which haven't been obtained. it would make no sense then for the board to consider the kind of predictive evidence that the
Then why
Alliance
do you
wants to
have
offer.
that in the standard?
The standard is a safeguard designed to ensure that the transmission lines aren't built unnecessarily. Your Honor is suggesting that a conditional permit
Yeah.
accomplishes that end, and that we agree with that. In fact, in
Can I
this
ask you
case,
this?
that was done.
Is there ever a request to grant a permit for the construction of additional transmission lines unconnected to some existing or proposed project? Right?
I don't know if there's precedent for that, but I would think then the issue would really be what's the need for the transmission
So you
lines.
either have an existing generator, whatever, generator of energy, whatever kind it is, and, they come along and say, we need more lines because of A, B, C, and D, and you can look at that, and there's no... The alternative is you've got an entirely new project. But the new project, nobody knows whether it will ultimately succeed because the permitting is so complicated for these projects, and there's so many delays, and there's so many backs and forth, and you go 2 steps forward, 1 back. I mean, don't you just issue a contingent permit?
The board is entitled to issue contingent permits specifically authorized by statute. The conditional permit, and I'm referring to paragraph 5 of section 69J, it's also the precedent of this court that a permitting agency has the inherent authority to issue conditional permits. And here, that conditional permit was fully effective.
Let's assume that we conclude that the second prong is absolutely meaningless. It's just meaningless. What do we do? What's the relief here? Because it is our very well-established law that you have to, the agency has to tell the world these are the standards by which we're going to evaluate, and it lets people like the Alliance or, neighbors or whoever it is to come in and say, no, you can't meet that standard. If the board has announced a standard and you're not telling me how it has any meaning, what do we do with that?
First, I suggest that it has meaning with respect to ensuring that the transmission line isn't built on. But let me address a second question.
Well, tell me the first, because if you tell me it's got meaning, that's different.
Well, surely you can envision circumstances, not here perhaps, where it might be meaningful.
Yes, Your Honor.
A power generator comes in and said, we're thinking about expanding capacity. We'd like to build some transmission lines to be ready if we do. And the board might say, you haven't demonstrated any seriousness about this, or that you, A, have financing or have even begun the formal permitting process. Come back when you really got something to put on the table, I suppose.
Or alternatively, that they're so far down the line that it's insured. But
let me ask you this. Did the board say if the wind farm is constructed, we find that its generating product meets the criteria for usefulness in the region? Did they say that, or did they say it by implication?
What they said in doing the alternative analysis under Turner's Falls, they
but you can't
conducted
do
that
that.
analysis. With respect to the post-1997 standard, they determined that the existing system isn't sufficient to transmit the power that will be generated by the wind farm.
If in fact the board had dealt with the issue the way Alliance suggests that it had and issued the permit for the transmission lines, could a developer then say, we've decided to abandon the wind generating transmissions, we want to seek a different type of plant, and we already have the permit for the transmission lines? Is that a possible scenario?
As I understand what the Alliance is saying, is that the board should predict. And of course, if the board predicts what the permitting process will be, there raises not only is it speculative and duplicative, but it raises the danger that the board would predict incorrectly, whereas what the board did instead ensures that the transmission lines won't be built unnecessarily.
Unless the wind farm is built.
Exactly.
It's specifically tied to a wind farm generating facility.
Exactly. If the Cape Wind gets these permits, then then the transmission lines will be needed because Cape Wind will be building the wind farm.
You made the argument that the board could exercise discretion to adopt the new standard during the adjudication because the earlier standard was an adjudicatory one and because the standard applies only in a limited number of cases. Yeah. Why does the fact that it will apply only in a limited number of cases make any difference?
As opposed to doing rulemaking. So that's one of the issues in the Chenery balancing. And
Well, I
so-
know that's the question, but why does the fact that the standard will apply only in a limited number of cases mean that it can be adopted as an adjudicatory standard rather than as a regulation?
In part because it was fact-dependent, and by developing the standard in the course of an adjudicatory hearing, the board was able to ground the standard in evidence. The alternative would be to change the standard prospectively and potentially not take in relevant evidence. Here what the board did was it applied broadly accepted evidence about both the generator and the transmission line, which is what the Alliance wanted. Then at the end of the hearing, it focused on the transmission line in light of the 1997 Act, and then it conducted an alternative analysis in which it also looked at the generator, which is what the Alliance had been asking for. So therefore, there was no prejudice to the Alliance. It got the consideration it wanted, just failed to succeed on the merits.
Let me ask you this. The board, as Alliance points out, especially in its reply brief, concluded that it could not, quote, yet find that the wind farm will be available to contribute to the regional energy supply. So it said, we can't meet our second prong. As I understand the Alliance, they're saying, oh no, given an opportunity, we could have demonstrated that the wind farm will not be available to contribute to the... Generally speaking, when you have a standard, you let somebody come in and present the evidence. As I understand their position, they were not given that opportunity because the board decided that it wasn't in a position to determine.
The board explained the likely to be availability prong as having to do with permitting. In this case, it made an uncontested fact finding that the permitting process was early on, and therefore they couldn't predict the ultimate outcome of it. And so to resolve that issue, they issued a contingent permit, which was a practical way to...
No, it's a practical way, but I'm just going to the fundamental. As I understand Alliance's position, Alliance said, I wasn't given an opportunity to demonstrate to the board that this wasn't going to succeed.
But the Alliance is talking about offering the kind of evidence that a fact finder wouldn't consider. Some expert on federal permitting speculating as to what will happen. This is a case where the wind farm will in fact go through the federal permitting process with a definite outcome at the end. Makes no sense for the board to speculate about ultimate facts that will happen. Instead, by doing the conditional permit in accordance with the statute, it achieves the end of the transmission lines not being built unless the wind farm is likely to be available. And so therefore, in a practical way, consistent with its statutory mandate to decide the case as the first state agency, avoiding unnecessary, duplicative, and risky prediction, the board resolved the matter in a reasonable, practical way.
Thank you, Mr.
Thank you, Your
D'Angelo.
Honor.
Mr. Rosenzweig?
May it please the Court, David Rosenzweig for Cape Wind Associates. The issue before the Court is whether the two complementary findings in need made by the Siting Board in its final decision conform with the requirements of Section 69J and were supported by substantial evidence. We believe that each of the findings is consistent with the Siting Board's statutory mandate and its delegated authority. Taken together, they form a strong basis for the Court to affirm the Siting Board's order. With respect to the revised standard review, as Mr. D'Angelo said, the first prong is the required finding that the transmission lines are needed. The Alliance does not contest that point. The issue was litigated at length during the case. The evidence was comprehensive, and the Siting Board's finding there is unequivocal. With regard to the second prong, it's an additional protection that's provided the Alliance, that transmission lines are not built unnecessarily for this wind farm that will be subject to the exclusive permitting of federal agencies. That's a protection to the Alliance. There is no evidence that the Alliance could have presented that would have more dispositively addressed their concerns than the condition that was imposed by the Siting Board.
Well, as the Attorney General says, to get into that second one, and based on what they want to present, would get into pure speculation, would it not?
It would amount to pure speculation.
We don't know what the feds are going to do.
Certainly. Cape Wind could have presented its view that it will likely proceed through the permitting process by the federal agencies. the Minerals Management Service being the lead federal agency, and the Alliance could have presented its claims, but nothing would have been as dispositive as the condition itself.
To Rosenzweig, I understand that, and I realize that I'm just going back to what I asked, Mr. D'Angelo for the board. Even if you take Justice Cordy's hypotheticals into account, you never know. Somebody comes in and says, I'm planning to do this. Why would the board not be able to do a conditional permit? The board may say, come back a little later, but if you have the standard, I fail to see when that standard can ever have any real meaning, because let's assume that the board had the functionally equivalent of Alliance, an existing generator planning to expand, and the board came in with, the minutes of its own corporate board. I mean, the generator came in saying, we intend to do this. And then, an Alliance comes in and says, well, they're not likely to succeed because we're going to pick at every permitting. It seems to me it's such a meaningless standard. So for you to stand here and say, well, it was actually to give them more protection, as opposed to saying this is just a contingent permit, and then for us to decide whether in these circumstances a contingent permit does or doesn't meet the statutory delegation is a different question.
The Siting Board's finding under the revised standard is tantamount to a conditional permit. What the Siting Board did was to be consistent with Section 69J and Section 69H, which says, pursuant to the Restructuring Act, that with regard to generating facilities, the Siting Board is to allow market forces to determine whether generating facilities are needed. So they made the finding with regard to the transmission line, and then with regard to the generator, that will be subject to licensing and permitting by other federal agencies.
So why do you need a second standard?
From the perspective of Cape Wind, it's an additional burden. The Cape Wind would have found the first standard to be satisfactory.
You always just say that here's a conditional permit, and by the way, to get to Justice Spina's question, we're now going to be very clear about what we are basing this on. It's going to be a wind farm equipment in Nantucket Sound. It's not going to be, when those permits go down the tubes, it's not going to be some alternative. And that's the way that you constrain, that you're not granting permits when you haven't satisfied the statute.
What I'm suggesting to the Court is that is in fact what the Siting Board did. They conditioned their approval that this facility, this transmission line was jurisdictional to them, will not be built unless this generating facility separately receives its permit. That's the same protection as what you're describing. They did it under a standard that they felt they could apply in this and other cases that would be amended to those other cases based on the case-by-case factual circumstances in those cases, whether it was a matter of permitting for other.
So would I be correct in concluding that I should simply disregard the second standard and view this only as a conditional permit and look at the statute and the regulations to see whether or not the board has authority to issue a conditional permit, which might run into some of the gatekeeping functions? I don't know that. But all of this fight has been over, we didn't have a chance to present evidence about the second prong, and I haven't been told by anybody how that, in any circumstance, would provide a record that a court could review to see that there was substantial evidence or there wasn't arbitrary and capricious.
We believe this is a conditional permit, and that the statute itself for the Siting Board says that the Siting Board has the authority to review, reject, or approve conditions, permits for applications for facilities within 12 months of their submittal. That's what they did here. The condition that this facility will not be built, this transmission facility will not be built until the wind farm itself receives its federal permits is clear and unequivocal. And the Alliance doesn't contest that.
Do we know what the status of the federal permitting process is now?
Subsequent to the Siting Board's decision, the federal permitting process changed with a congressional act that delegated the lead authority to the Minerals Management Service as opposed to the Army Corps. But that process is underway and is continuing, and the Alliance is a participant, as are many other parties. The federal permitting process continues. It will be going on, and the issues with regard to the wind farm itself will be exhaustively reviewed by those agencies, and parties will have their rights to.
Mr. Rosenzweig, is there a time limit within which this conditional permit can be exercised, the grant of this conditional permit can be exercised?
The Siting Board's order did not provide a precise time frame within which the federal.
Let us assume, for example, what I see here, and I believe it is, you cannot construct until your client has submitted to the Siting Board copies of all permits required to begin installation of wind farm equipment in Nantucket Sound. Let us assume that this project takes a very long time. How many years has it been in the making so far?
Several years.
How many?
5.
Okay, let's assume it takes 25 years. Is there some point at which this permit is no longer valid? Because who knows whether or not there's a need any longer.
The Siting Board's permit does not provide such a provision, but there is a provision in the order itself that says if there are changed circumstances of material nature, it is incumbent upon Cape Wind to present those changed circumstances to the Siting Board to allow the Siting Board to determine whether the original findings on which it made its decision are still hold. That's a provision that's in the final decision. It's in all Siting Board decisions and would be in effect here. Consistent with the Court's precedent, the Siting Board has broad discretion to establish a revised standard review based on the requirements of the Restructuring Act, as well as the authority to make alternative findings on need using its historical precedent from Turner's Falls. The catch-22 that the Alliance inherently presents, where the Siting Board cannot apply its revised standard review or its former standard review, is simply untenable. We believe that the Siting Board was well justified in finding need based on both standards of review, and in no event should it be found to have acted outside its authority by applying the standard under both standards in this case. We believe that the need determinations by the Siting Board were comprehensive, fair to all parties, and consistent with the statutory framework. We therefore ask the Court to affirm the Siting Board's order.
Thank you, Mr. Rosenzweig.